Welcome to all of our delegates. We've got a number of delegates all over the UK and indeed internationally. Welcome to the first event in 2024 of the Institute of Arbitrators in the Thames Valley. My name is Mark Thomas. I'm a past chairman of the branch, and I'm the organizer for this evening's meeting. You'll see various little webcams there on the screen, and I'm going to be joined this evening by James Richardson, who is the vice chairman of our branch, and he's the sort of IT coordinator this evening for running things. And then our main speaker, Rob Langley, who I will introduce in a couple of moments, and Dr. Isabel Phillips, who I will likewise introduce very shortly. Before I get on to this evening's main topic, I'd like to just say a few words about the Institute of Arbitrators and about this branch of the Institute. The Institute of Arbitrators, although it's in the name that we should be arbitrators, the vast majority of our members are not arbitrators, and it covers expert witness work, it covers adjudicators, it covers arbitrators, obviously, and it covers mediators. And we have 17,000 members in 139 countries, which is across 42 branches worldwide. And we have 14 branches in the UK, and the Thames Valley is one of the most active amongst the UK branches. We hold about a dozen events each year. This one tonight is being held purely as a webinar because logistically we couldn't get the dates to work, and Rob, who is based in the Northeast, wasn't going to be anywhere near the Thames Valley anytime soon. And we wanted this particular event to be held reasonably quickly, which is why we're doing it as a webinar. But other events will be held throughout the year. You can already see and book our next event, which is the only one I'll mention. You've all been through our website. Our next event is on the 7th of March, when builder barrister Tony Bingham, known to many in the construction industry, will be talking about 25 years of construction adjudication and Viagra, with the question, which has been more effective? Now, that's going to be held face-to-face in Milton Keynes, but also as a hybrid event for you to be able to see online. So if you want to know more, just go to our website and we'd be delighted to see you in a month's time. Turning to this evening, we are going to be joined later on this evening by Dr. Isabel Phillips, who is the Director of Policy and ADR Development at the Chartered Institute of Arbitrators. And Isabel is an experienced mentor, a mediator. She's an ex-CEDA trainer, and she has been intimately involved with the FCIArb's intervention in the Churchill case, and she'll be able to tell you and add to the comments being made this evening at the end of the talk. So finally, before I then ask you to or introduce Rob, just to say, as James has mentioned, if you have any questions, we have a lot of people on the call tonight. We can't have people interrupting, so please find the Q&A box. If you have it on full screen, it should be at the bottom of your screen. If not, click on the three dots and it will come up as a pop-up to give you the opportunity to go to the Q&A. Pop your questions into the Q&A and we'll read them out at the end. So Rob is our speaker this evening, and he's an experienced mediator. He originally trained as a barrister and he then re-qualified as a solicitor. He was active in commercial litigation involving engineering and construction. He then went onto the management side in his practice, which is large in the Northeast with more than 300 staff. During his tenure of the firm, he also expanded into London, and then, of course, they went through the recession. And I like the part of your CV, Rob, where it says that experience and also having 3 teenage daughters has informed and sharpened your approach to ADR. So, Rob, the floor is yours, and we'll be talking with Rob and Isabel later. So, Rob, I'm going to hand over to you for our presentation, please.
Thank you very much, Mark. Thank you. And good evening, everyone. Some of us here this evening may recall the 1990s. By the 1990s, just due to increased activity and increased willingness to go to court and increased need for dispute resolution, our courts were absolutely clogged with cases. It was very difficult for anyone to get a trial at an early date. I'm just going to remind myself that I need to share the screen.
You do.
I do. That's a bad start. Here we are. I'm so enthusiastic. Yeah, and I can just get this to, yeah, slideshow. There we are. Okay, good. Okay, so there's my, oh, and we're on the complete, yeah. And I'll just rewind to the start. Such an expert presentation, this. So the topics I want to cover this evening, it was a quick introduction about the bad old days, and then look at where we are at present, the status quo, the carrot and stick approach the courts use to encourage mediation, a slight digression into the court's attitude to contractual arrangements to mediate or to use ADR, and the gradual growth of judicial approval and support. The big problem that we've had for 20 years with Article 6 of the Human Rights Convention. The reasons that have been aired over the years in the quite fierce debate for not making ADR compulsory, the current plans the MOJ have for full-on compulsory mediation, consequently the government's intervention into the supply of what essentially we would all regard as our private practices as mediation suppliers. I'll look at what the post-Churchill world and what is the Churchill case, and finally some conclusions, after which I'll hand over to Mark and also to, of course, to Isabel, who will have a lot to say about that. So forgive me, going back to the 1990s again in my little time machine. 30 years ago, the court system, the civil court system, was the poor sister of the criminal and the family practice as it is nowadays. It was a wee bit of a shambles, a lot of excellent people trying hard to make ends meet with limited resources, and enormous pressure of the sheer number of cases and the size of cases waiting to go through the courts. And there was a huge and successful drive led by Lord Harry Wolff, who revised the Supreme Court practice and gave us the civil procedure rules with the novel idea that the court should have an overriding objective to achieve justice proportionately and fairly. The Housing Grants Construction Regeneration Act, which really transformed one of the most problematic and seriously congested areas of litigation, which is construction litigation. It gave us the statutory right to adjudicate, which has taken a lot of pressure out of construction disputes. The improvement of the technology in construction courts, the increased professionalism of the judges. So things got a lot better. And now gradually by some process of entropy, they've got worse and worse and worse again. And now is the time for a new drive to reduce the volume of work going through the courts through diverting the cases to alternative dispute resolution. No, this isn't just about mediation. This is about all the different ways of resolving cases outside of the court process. 2021, the Civil Justice Council came up with a very interesting report from its ADR liaison committee, which broadly concluded that we had to start using ADR and that we could do so legally, despite people's worries about Article 6. And then the following year, 2023, the MOJ, having read and very much taken notice of the liaison committee's report and having taken soundings and inquiries from society and the marketplace, produced a very interesting consultation, increasing the use of mediation. Last year, in 2023, we then had a press release from Lord Bellamy, who is the court's minister and a very active and clever man, basically reporting on how the MOJ is carrying forward these groundbreaking reports of 21 and 22 and their plans for the county court, which are now in hand, as we shall see. So looking at CEDA's a biennial, that's every 2 years, audit of mediation, which came out February last year, Nobody really knows how many mediators there are in the UK. I think we all know that there are more and more of them. And most of us probably know someone who wants to become one or has just managed to become one. Certainly CMC, Civil Mediation Council, has more than 700 on its books. Interestingly, as at February 23, it was 649. Now it's more than 700. So the number of registered mediators is growing. 92% of mediations were in CEDA's researchers and experience successful in outcome. And that mirrors my own experience in conducting mediations in my civil and commercial mediation practice. CEDA estimates that this level of activity saves the economy over £5 billion a year. I don't know whether that's correct or not. I'm certainly quite convinced that each mediation that one manages to successfully resolve takes an awful lot of expense off people's shoulders, closes things down, reduces their stress levels, gives them a result they'd otherwise have waited years for, gives them control, and saves them money. So perhaps that's correct, perhaps it's a larger or smaller sum. It's certainly a very serious figure. How the courts currently manage the mediation process is by what I would call the carrot and stick. So Lord Justice Aspelin famously said in 2022, the carrot I offer to the parties is the peace of mind and saving in cost that would come with a negotiated settlement. The stick is that any party who is not willing to engage in this process risks finding themselves to an adverse costs order. And there's a standard court order called an Langley, UNGLEY order, which is a little format, a little protocol for ordering the parties during a stay that's provided or a suspension of proceedings that's provided for that purpose to try an ADR process, usually mediation. If either party refuses to do so, simply does not want to do so, they're free to refuse to participate, but they must make a report not less than 28 days before the trial starts, explaining themselves and as to why they refused. And if in due course they then win or lose, and the other side says, well, if only you'd mediated, this would have happened, they then have to justify themselves by reference to certain tests and standards. They have to justify themselves. And increasingly, the courts have been looking harshly on people who do not try mediation. However, it all starts more than 20 years ago with a Court of Appeal case called Dunnett versus Railtrack. We don't have time to go into the facts of that this evening, although they're very interesting. But in that case, Lord Justice Brooke referred to the civil procedure rules, which we've had since they were generated in 1996. And Part 1 of those rules provides that there is an overriding objective. That objective is to deal with cases justly and at proportionate cost. And the court has a new duty, it's only had since 1996, of actively managing the case. So the judge is no longer simply an umpire sitting at the tennis match, watching the two King's Counsel lobbing the balls over the net. He or she now has to get involved and say, well, I don't want you to do this. I do want you to do that. I want to hear more about this. I want to do less of that. I want you to produce documents or get experts' reports and so on and so forth. And part of actively managing the case is to encourage the parties to use an ADR procedure and to facilitate that use. The parties have a duty to work with the court to achieve their overriding objective, and that means, by implication, the parties have a duty to try ADR. 2 years after Dunnett, which was regarded by the mediation industry, which I am a small part, everybody was very, very excited and pleased about the 2002 decision of the Court of Appeal. We had recognition only a few years after the whole concept of mediation came across the pond from the United States. Suddenly we got the Court of Appeal giving us a ringing endorsement of the value of mediation and a stern warning to parties who refuse to participate that they will pay the consequence in costs. And then what seemed to be a massive setback in 2004 when a differently constituted Court of Appeal established two important principles in Halsey versus Milton Keynes NHS Trust. Firstly, the court would not order parties to mediate because this might well infringe Article 6 of the European Convention on Human Rights. And we'll come on to what the text of that says later on. And further, there was a lot of skepticism in the court as to whether it really was sensible to order people to mediate if they didn't want to, because of the essentially consensual partnering idea of people negotiating, sitting and talking to each other, being open with each other, sharing views, sharing possibilities in a without prejudice context, which is what mediation is all about. And Dyson said, it seems to us that to oblige truly unwilling parties to refer the dispute to mediation would be to impose an unacceptable obstruction of their right to access to the court. So that was one thing, and that's been a massive problem ever since. And that's what the Churchill case has now resolved. So we're making progress. It's only taken 21 years, but 20 years, but we got there. The second thing, however, that Halsey established is still very much with us, and that is the concept of cost penalties and the tests for applying those cost penalties. Dyson decreed that the burden of proof is upon the losing party to persuade the court that the other side has acted unreasonably in refusing mediation. So I go to court and I lose, and then I stand up and say, although I've lost, I shouldn't have to pay the costs to the winning party because I offered them to mediate, and they'd have got a better deal if they'd mediated than if we fought all the way to court and had all these irrecoverable costs on both sides. The burden of proof is on me if I'm the loser seeking to reverse the burden of costs. It's on me to persuade the judge that is the right thing to do. The lordships laid down 6 factors for us to take into account, and they're still really important. The nature of the dispute. I mean, if a case is a binary dispute, you either want a divorce or you don't. What are you going to do? You can't mediate a yes/no decision. Cases involving fraud. If someone's a fraudster, how can you trust them enough to mediate with them? How could you ever enforce the judgment? The settlement agreement. So some disputes might just never be suitable to mediate. The merits of the case. Is it reasonable to go to court believing with a case's opinion that you're going to win? This is one of the grounds that's been eroded over the years as the judge has been increasingly reluctant to allow someone to simply say, well, I thought I would win, therefore it was reasonable not to mediate. That's a dodgy ground. I wouldn't use that one too confidently if I was you. One might stand up and say, well, I refused to mediate because we'd already had a structured negotiation. We'd already had elaborate settlement discussions. We've had endless without prejudice correspondence. We simply can't agree. Or we tried an expert evaluation and we got nowhere. So the courts might take the view that you've tried other settlement methods, fair enough. You can't say that the costs of mediation would be disproportionately high. And you may say, well, it's a simple matter. But I myself found in a property dispute I did last year that one of the parties was spending £12,000 just to have its day in mediation. And by the way, none of that was my fee. And the dispute was £45,000. They were spending 12 to have the mediation. Basically, they'd appointed the wrong lawyers and the wrong counsel, who are extremely expensive. But that mediation cost far too much for the matter in question. We settled, but at enormous cost. Mediation would cause a disproportionate delay. Somebody who suggests a week before the trial they want to mediate is just stalling. You really don't want to, when you're all ready to go to trial, you do not want to ask for an adjournment so that you can mediate. Does the mediation have a reasonable prospect of success? I think, again, this is a very problematic ground now. I mean, every mediator can tell you stories of one party or the other saying, look, this is a waste of time. There's no point having an opening session. There's no point explaining our case. Everybody knows this. We'll never agree with them. The other side are complete so-and-sos. I did a case 2 weeks ago in Bath, where 2 sisters were fighting over the probate of their father's estate, quite a large estate. both of them said beforehand, there's no point talking to her. She's a so-and-so, so-and-so. She never stops talking. She's horrible. She's aggressive. She's nasty. They were both reasonable people. They both had this terrible view of their sibling. We had a long, frank, tough series of private sessions, very courteous, very, very open. And at the end of it, we did a resolution and we sorted the whole thing out. Because building a bridge between people, however obdurate, however much there is even hatred between people, a mediation can sort that. So I'm very skeptical of people saying, well, I don't think the case had a reasonable prospect of success. But those are the 6 factors you're going to have to use if you're in trouble because you refuse to mediate. Just moving sideways, the courts aren't just leading up to and following Churchill, very sympathetic now to the concept of ADR. They're also increasingly supportive of contractual arrangements to go to mediation, but it's necessary to draft your mediation clause very carefully. You can't just say, if we have a dispute, we'll go to mediation. You've got to jump through several hoops. So the excellent, this is Justice Finola O'Farrell in Open versus Invesco, was dealing with a contractual ADR clause, which actually said, if we can't agree this matter, then we won't go to court until we've tried mediation. We'll use the CEDA mediation procedure. We'll have, if we can't appoint the mediator by agreement, we'll get CEDA to appoint one. We'll abide by their rules, etc., etc. And Finola identified 4 tests that you must pass to get a stay of proceedings. 1, the contract must create an enforceable obligation to engage in ADR. 2, that obligation must be expressed as a condition precedent. You don't need to use that phrase, condition precedent, but it must be clear that you have to do A before you can get B. Thirdly, the resolution process, the dispute resolution process to be followed does not have to be formal, but it has to be sufficiently clear and certain by reference to objective criteria. So here you have the CEDA model mediation process. A machinery to appoint a mediator to determine the steps in the procedure without the parties having to sort of agree further matters. In other words, the court won't enforce an agreement to agree. It wants something concrete where it can just say, do that, and it can enforce it. And then fourthly, one has to show the court there is either a public policy interest in upholding the parties' commercial agreement, which of course there almost always is, or alternatively, that the stay to dispute resolution, which you're asking the court to grant, will further the court's overriding objective, which is to do justice by proportionate means, in that it will assist the parties to resolve their dispute. So this case was, let me see, in 2019. Just 3 years later, another Justice of the High Court, Mrs. Justice Joanna Smith, in Children's Art Partnerships versus Kojima Construction, refused an application to strike out to mediate. Again, she enforced an ADR clause. She was referred to and reviewed the OPEN decision, and she ruled that item 2 was incorrect. Item 2, remember, is that the obligation must be expressed clearly as a condition precedent. She said that wasn't necessary. It's not necessary to show that there's a condition precedent as long as there is a mandatory obligation. In other words, we agree that if there's a dispute, we will go to mediation. It wasn't necessary to say we won't go to court until we've mediated. All you had to say was if we have a dispute, we will go to mediation. And she did, however, apply test 3. That again shows the importance when you're drafting your mediation clause of putting some sort of enforceable, definable, tangible process into it. So what's all the fuss about with Article 6? Well, Article 6 of the Human Rights Convention, which of course is embodied in our law in the Human Rights Act, says that in determination of one's civil rights and obligations, Everyone is entitled to a fair and public hearing within a reasonable time by an independent and impartial tribunal established by law. Among the many cases toing and froing about whether or not Article 6 is relevant or not, in 2019, Lord Justice Moylan, who was being asked to rule that the civil procedures provision for a compulsory early neutral evaluation was or was not contrary to Article 6, decided to enforce early neutral evaluation, despite the compulsion element, remarking that this process was merely a step in the way to the courtroom. It did not obstruct the parties' access to the court, and it was not an unacceptable constraint. In other words, just as the duty to make disclosure of your documents before you can have a trial, to exchange your witness statements before you can have a trial, to serve properly prepared and appropriate pleadings before you can have a trial. Going to mediation, going to early neutral evaluation is simply a step before you can have a trial, and therefore no different, and certainly not in any way unusual or outrageous or oppressive. So that was the judicial thinking at Court of Appeal level in 2019. So it was only a matter of time before a suitable case came along. And that case was Churchill versus Merthyr Tydfil, County Borough Council. And in this case, Mr. Churchill owned a property in the district of Merthyr Tydfil in South Wales, and he pursued a claim for knotweed contamination against the council because the knotweed had spread from the adjacent land owned by the council, which had failed to control this pest. He didn't use a normal solicitor, he used a claims specialist. The council had in the meantime asked him, would you first, we're sorry you've got a claim against us, can we please refer you to our corporate complaints procedure? And he said no, or his advisor said no, and they commenced proceedings in the county court. So the defendants, the council, applied to the court and had a hearing before the deputy district judge, who ruled that he could not grant a stay to refer to this ADR process because of the human rights issue, Article 6, identified in Halsey. And I had the privilege and advantage of having a long chat with Mr. Whitewick, who was junior counsel for Merthyr Tydfil in the case. And he explained a lot of the background, which was absolutely fascinating. And part of the council's motivation for seeking this stay was that there are serious problems in the public housing and social housing sectors with claims specialists seeking out people with grievances like Mr. Churchill and pursuing large numbers of claims through the county court and generating costs which are avoidable and in many cases unnecessary, because all that's needed is an investigation and resolution process which is voluntary and which would take a lot of cases out of the courts. And of course, if I was running a claim like this, I might have an interest in keeping the case going. I'm only speculating. So the council was very, very anxious to win this case because it was anticipated that it would give a shot in the arm to all the internal complaints procedures which housing associations and local authorities offer to their tenants and their neighbours. So it remains to be seen, but so far the signs are that this is definitely going to encourage that form of alternative dispute resolution. So it just shows how we shouldn't assume that ADR is simply mediation. It's not. There's an awful lot of internal procedures, reconciliation procedures, internal complaints procedures, which people use, which the courts, it looks like, will be very willing to support and encourage and grant stays for. So the council appealed the district judge's decision, and a number of parties intervened: the Law Society, the Bar Council, Civil Mediation Council, the Institute of Arbitrators, the Housing Law Practitioners Association, the Social Housing Law Association. The latter two, obviously, because of that volume claims concern that housing and social housing practitioners have. Rather encouragingly and interesting, the Law Society intervened to challenge the idea of making mediation compulsory in 2004 in Hornsby versus Milton Keynes. This time, the Law Society, along with the Bar Council and the CMC and so on, intervened to support the Council's point of view and to advocate for an interpretation of Article 6 of the Human Rights Act, which does not deter and impede a facility to order the parties to go to mediation in appropriate circumstances. So what this Court of Appeal in 2023 did with the decision in 2004 was to rule that actually the very eminent learned Lord Justice Dyson wasn't wrong, but what it said about compulsion in Article 6 was obiter dicta. That is to say, it was something that was a remark on the sidelines, it was not a remark, it was not a comment, which was critical to the reasoning path of the case. It was simply the judge thinking out loud, as they very often do in judgments, and things like that can be very helpful as guidance or indication, but they're not binding. Only if the reasoning or the opinion expressed by the judge is part of his actual analytical decision-making process do we regard that as being a binding statement of the law. So the Court of Appeal in 2023 solved its dilemma with the previous decision of 2004 by ruling that it was obiter. It was just an incidental remark, and therefore they weren't bound by it, and therefore they were safe to say Article 6 does not impede reference to the facility of compulsory mediation. However, in this particular case, sorry, Merthyr Tydfil, there's been a lot of water under the bridge, a lot of legal costs have been spent. It would be foolish to go to your internal procedure now, so we're not going to grant you a stay. So that case will roll on, unless it negotiates and settles, of course. That will roll on to a trial in the county court, and it will be dealt with one way or another. The result, no doubt, will not be reported. But the irony is that the council won the war but lost the battle. So, still with Article 6, where are we now with Churchill? Well, we now know that the High Court, the County Court, has the power to stay a case, to suspend a case, and order the parties to go to try an ADR process, as the judge sometimes say, to try a non-court assisted dispute resolution process. We know that we're not breaching the European Convention. We know that we're complying with the overriding objective to do justice at proportionate cost. The court was pressed by these various interveners. Please give us a shopping list of when the court must order the parties to mediate. And the Master of the Rolls, Sir Geoffrey Voss, sitting with the Lord Chief Justice, Lady Sue Carr, and another distinguished Lord Justice of Appeal in Ordinary, three top Court of Appeal judges, some of the most senior judges in the land, said, well, no, we're not going to give you some sort of binding guidance. It's up to each judge to take her or his own decision on, is this case appropriate to force the parties to try ADR? In other words, should I use the carrot and stick process and leave it to work out by reference to hindsight afterwards, whether that was good or not? Or should I actually say, no, it's important you actually do try ADR, whether you want to or not, I'm ordering you to do it. And all that Sir Geoffrey would say was, provided the order doesn't impair the very essence of the client's claim to proceed to a judicial hearing, well, that's pretty unlikely. And providing that ordering compulsion is for a legitimate aim of settling the dispute. In other words, if I'm asking the court to order the other party to mediate on vexatious grounds, I know they haven't got very much money, I know they can only just afford to go to court, and I know that if I make them mediate because they're using the QC and two juniors and an enormous law firm, it'll cost them £20,000. So I'm doing this to crush the other side with costs or something of that sort. If I'm doing that, I'm not going to get an order to go to compulsory mediation. I have to be acting legitimately. Am I acting proportionately? Is the mediation going to be a fair, fair? Is it going to be fair to do this? Is it going to be quick to do this? And is it going to be at reasonable cost? If the other side's in Australia, they don't have bandwidth, they can't use Zoom, or Zoom's not, or Teams isn't appropriate, you can't ask them to fly all the way to London for a hearing, that would not be, it wouldn't be reasonable to order them to mediate. So you can see how A, B, and C will very occasionally prevent an order, but I think that's working within those three parameters gives a judge a very, very broad discretion to order compulsion or to choose compulsion if she or he thinks that it's a good idea. So the Court of Appeal further refused to give any other guidance, as I've said, but it did refer to the guidance in Halsey. In other words, those 6 criteria, which you've got on the slides. By the way, I believe talking to Mark, Thomas, and James before this talk, that they are intending to send out the slides afterwards. So I've drawn up these slides with a lot of material on them. They're quite dense, but hopefully you should find them as a useful memoir, aid memoir of the points that I've made. And so you've got the tests there to cut out and keep. There are still a lot of people who think that mediation shouldn't be made compulsory and are concerned with the effects of doing so. Certainly the Civil Justice Council was concerned that promoting ADR would somehow undermine the role of the courts. Personally, I can't see that. My typical experience of mediation is that both parties are worried about how much it's costing them. And if they aren't, that's because they haven't actually looked at what they're spending yet. And part of my job is to make sure they actually understand just what they're spending and what they're going to spend. So I don't think that ADR undermines the role of the courts. I think there is such a lot of pressure on the courts and so many cases waiting for trial that we're actually working, we mediators are working in tandem with the courts to help the justice system to operate at proportionate cost, to quote the overriding objective. There's a big concern, which I totally understand, about intransigence, people who are obdurate, people who will not use mediation to settle. And there'll always be a few awkward cases like that. However, the CJC had done some very interesting research. They'd looked at 5 or 6 structured compulsory mediation systems around the world. And the one that particularly struck me was their study of the way that the province of Ontario in Canada operates its mandatory mediation process. And I put a link which you can copy and paste from these notes. And I do recommend that you have a look at the Ontario civil procedure rules. This is a link to their descriptive protocol. It's about 15-20 pages long, and it's very interesting as to how it works. It doesn't cover all mediation, all disputes. It doesn't cover, for some reason, it doesn't cover construction cases, for example, but it covers about a huge majority of them. And the experience there is that practitioners in Ontario have got used to the idea of mediating. They know that sometime within 90 days from the receipt of the defence, so in other words, more or less at close of pleadings, they're going to have a mediation. So preparing for the mediation, thinking about the mediation, has become part of the process of running a court case. If you're a practitioner in Ontario, and their success rates are impressive. The third option. Well, no, let me just come back to that. There'll always be intransigent parties, but it's surprising how often in practice, when you mediate disputes, one side or the other, they have contempt for the other side, they have contempt for the case, they are angry, they are possessive of their grievance, of their cause of action. It's theirs. But once you can get them away from positions and into interests, things start to change. The ice starts to crack, people start to think in different terms. So mediation is powerful, and it will deal with maybe half or more of the really intransigent cases, but there'll always be the occasional tough nut. I had one mediation I observed. I still like observing cases now and again. And I observed this mediation, and the defendant said to my colleague, the mediator, he said, you're right. He says, I can see how I could lose this, and I can see how the other side, you know, it's been very unfair what's happened to them. He says, but I hate the man and I want to see him suffer. And I've got lots of money and I can afford to go to court. So that's what I'm going to do. There's nothing you can do with that, really. And the mediation didn't settle, and they did go to court, and that was just a tragedy. But that's a very, very unusual case. Thirdly, the mediation may be too costly. That really concerns me. Why do we have to make mediation so expensive? Why do we send a solicitor and a barrister to a mediation process? Why do we have to have huge, elaborate piles and piles of paperwork? I'm one of those mediators that likes to read everything. I have colleagues who aren't really interested. They want one piece of paper, then they just go in and start talking. I'm not that good. I like to sort of read everything I can to understand where each side is coming from and see, you know, where the body's buried. But mediation should not be that expensive. It's just people talking in a room. So I think we lawyers, speaking as a non-practicing solicitor and a former barrister, we do need to kind of look at ourselves in the mirror and ask ourselves why we're so expensive and how we justify it and what we're doing. Then fourthly, the dispute may be just too complex for mediation. And again, maybe that's the case. Sometimes there are just too many issues for people to take in. But at the same time, isn't mediation about getting to what matters and drilling down into it? Or having a structured mediation, or taking weeks or even months over periods of time. I can see it's a criterion, but I don't think it should worry most people most of the time. When is the right time to mediate? I think a lot of High Court judges certainly think, and Lord Justice Coulson has said, the trick in many cases is to identify the happy medium between the point when the details of the claim and the response are known to both sides, but before the costs have got so great that they are now the tail wagging the dog and you can no longer do a deal. My worry is that you get a mediation at early stage before people have thought through, analysed and understood their own claims. And you're asking them to sign a full and final settlement agreement without really knowing what it is they're fully and finally settling. So the earlier you do your mediation, the more money you save, but the greater the risk that you take, including the risk, the professional risk as a mediator, that you are engineering an unjust outcome. There's a very good discussion of the merits of this at section 1410 of volume 2 of the White Book, the Supreme Court Practice. So the MOJ, having taken note of the CJC's conclusions, particularly took note of the CJC saying that to ensure mediation processes are neither too onerous or too expensive, the state needs to step in with regulation. So there we are. That's the genie out of the bottle. Regulation of mediators and mediation is coming our way. So Lord Bellamy wrote his consultation in 22, and he said, and it's an interesting and very readable prologue. This is a report it's on the web, it's free, it's worth having a look at. To enable mediation, we need to ensure high quality, affordable and accountable mediation services. And the buzzwords there, ensure that mediators are accountable. And that's what they're going to do. But we'll see that this is a Faustian bargain. We're going to get more regulation and interference with what we do, but we're also going to get a lot more commercial opportunity for mediators in the private sector. So the MOJ is talking about embedding mediation or ADR as an integral part of court procedure. And the first step, and this is happening, is that all specified money, that's a technical expression, small claims, and there's about 180,000 small claims a year, all of those are going to be automatically stayed for 28 days at a certain point in the process. There's already a cadre of small claims mediation small claims mediators in the SCMS, that's going to be increased by 7-fold, 7 times as many. And according to the press release that came out in July, I think, 2023, they've already recruited half these people and trained them, and they're working on the other 50%. So the mediator will, everybody will be offered a free 60-minute telephone service. The mediator will be a trained civil servant, and at present time, the success rate is running at 50%. So they're taking 90,000 claims out of the pipeline already. Once everything stayed compulsorily to mediation, that proportion can only go up. It's not going to be 100, because they'll catch all the stuff that's too complex, too difficult, too unfair, too intransigent, and so on and so forth. But it will be more than 50% in future, and that's a lot of mediations. But there again, that's a mediation process which is a glorified horse trade, which most of us professional mediators wouldn't really recognize. I don't really want to go into that. What I want to talk is what happens next, because Lord Bellamy's made it clear, and he's the Minister for the Courts, that the MOJ's ambition is to extend compulsory mediation to all county court users, all of them, up to the £100,000 limit. However, it's recognised expressly that this is going to involve using private sector mediators. So that's why the government has decided that it needs to and will intervene in our profession to ensure quality, consistency, and integrity of mediation services. Of course, those of us who don't actually want to get involved in work that's been thrown out by the courts don't need to have anything to do with this, but most of us who are looking to actually run our mediation practices as a business will necessarily be engaging with this. So it's not just the MOJ. You have the Department of Enterprise and Industrial Strategy. In 2022, it issued its plans to impose mandatory accreditation of mediators handling consumer disputes. And there's probably some people listening this evening who have experience of that. It'd be interesting to see what they make of it, what their feedback is. The MOJ has trifled with the idea of a national standard for mediation, and of asking the British Standards Institute to set this up, but that seems to have been dropped, probably because there's a perfectly good suite of documents produced by the EU, which actually does that job of a code of conduct for mediators and a code of conduct for mediation providers, such as CEDA, such as the Association of Northern Mediators, the ADR Group Limited, and so on and so forth. I would say, because my background is it was originally in construction and engineering, so I'm a construction adjudicator. If you look at construction disputes, all the enabling acts, the 1996 Housing Grants Construction Regeneration Act, all that act did was set up a very broad framework for adjudication nominating bodies and adjudicators. Anybody can set up an adjudication nominating body. Anybody can be an adjudicator. Those of us who take it seriously, have accreditation, do training, do CPD, that is all voluntary. So the market has been allowed to provide schemes, training programs, complaints procedures, professional indemnity insurance, and cadres and panels of arguably generally competent and uncorrupt and available adjudicators. So why not let the market do it? It doesn't look as if this present administration, and probably the one we're going to get by this time next year, are interested in not regulating, not intervening, not compelling. So we are going to get intervention. What the MOJ, I think, now has in mind is recognising an existing body or an existing group of bodies. For example, I know that I gather that the CMC and the FCIArb and CEDA are talking to the MOJ at present, and I regard that as a bunch of clever, experienced and organisations with high integrity, most of which I'm a member of, having discussions with the government to produce something by consent, and that hopefully is good regulation which comes from the consent and the participation of the marketplace. Oops. So I mentioned the European Code of Conduct for Mediators. It does all the things you'd expect a mediation code to do. It's been adopted by the Civil Mediation Council as a yardstick, which I, as a registered mediator with CMC, have undertaken to comply with, including even having a complaints procedure and so on and so forth. So that work's already been done. So what next? Well, once they've got the 1 to 10,000 cases, that 180,000 of cases under their belts, the MOJ in their wisdom are going to roll out mediation for the, or I should say ADR, for the 10,000 to 100,000 value county court cases, many of which are multi-track. That's the technical jargon for complex and higher value disputes that take more than one day to try. And this is overtly recognised as involving us, the independent civil mediator, commercial mediator profession. It could potentially affect the terms on which we practice. It will affect the terms on which we are regulated, the CPD we're required to do, the nature of our record keeping, the nature of our feedback and accountability programs. Something else that needs to be done before we can say very much more about what the new world is going to look like is the Civil Procedure Rules Committee, which does what it says on the tin. They haven't done anything yet. I've been on their website and had a look, and I mean, it was only the 23rd of November that the Churchill case was generally published. And I think everyone's still scratching their heads. And I think there's an extent to which the Rules Committee is looking at the MOJ and the MOJ is looking at the Rules Committee. I had a very interesting conversation on Monday evening with some High Court judges about this, which I'm not sure where I want to insert this into the presentation. Yes, here we are. I was lucky to attend a meeting of the Business and Property Courts Forum for Newcastle upon Tyne. You probably know that all the city regions, Manchester, Bristol, Newcastle, Leeds, and so on, they all have a business and property court. And a policy decision has been made to drive work out of London to the BPC centres in the regions for various reasons. And we had the Chancellor of the High Court, and we had the Vice Chancellor of the County of Lancaster, who's responsible for the North East and the North West circuits, to talk to our BPC forum. And there was 200 people there on Monday evening in Newcastle. And it was a question and answer forum about the future of the BPC in Newcastle. It was a fantastic experience to have these very high-powered senior judicial officers discussing things with us. And I asked them what they thought the practical effects of Churchill was going to be. And the one answer was, if we order people to mediate and they refuse, what's the discipline? We can't refuse to allow the case to go to trial. That would be to punish the innocent litigant who wants their decision from the courts just as much as the guilty litigant who won't cooperate in mediating. So it's not going to be, you can't ever go to court because you've refused to mediate. That will be used tactically by people who didn't want to have trials. So it's always going to be a costs penalty that we resort to. So how different is it going to be from the current carrot and stick? And that was a very interesting insight by a very shrewd, very senior High Court judge. And then the other person said, look, it is an extra tool. We will certainly be using it. And there's a tactical implication here. Lawyers will start saying, we want to go to mediation. What do you think? And the defendant replies saying, no, I don't think so. Or the claimant says, I'm not mediating. I've got a great case and I'm going to win. Halsey tests. And the next thing will be that the person who wants to mediate will apply to the court for an order, if you like, a Churchill order, to compel the other to stay the case and compel the other side to try mediation. And On the one hand, if you refuse to mediate and you go to court and the other side then stands up and says they should be made to mediate because they refused, the burden is on the applicant to justify this argument. And you can just sit there and wait till they make their case, and you may win. You've got at least got a dice to roll. But on the other hand, if you've been ordered to mediate by the court under Churchill and you've refused to actually engage in the mediation process at all, then you are going to pay the costs in due course, whatever the Halsey merits. So compulsion has got its place in the judicial toolbox. So just these final points. Yes, there'll be some wasted costs due to intransigence, but I think we should practice mediation in optimism and energy and hope, and most cases will probably go on settling. Yes, it'll be difficult to actually mediate at the right time before you've wasted too much money on costs. But on the other hand, it must be the case that the number of cases settling will increase. That will benefit so many people. So many people will wake up in the morning after the mediation and that weight of oppression and worry is gone from their shoulders. One of the problems we have is that our legal profession, load of fantastic people, not everybody actually understands what they're doing when they're mediating. They'll quickly get better because the more they use it, the better they'll get at using it. So I'm confident the profession will get better at mediating as it gains more experience and it becomes more of a mainstream planned in activity like it is in Ontario. So those of us, you and me this evening on this discussion, who are mediators or who want to be mediators, have got to start thinking about professionalizing. Get yourself registered with the CMC. Get yourself onto the FCIArb President's Panel. Go and join CEDA sooner rather than later. Do all of those things. Because while the new Churchill powers are to order a non-court-based dispute resolution process, if you want it in jargon, not just mediation, in reality, it's mostly going to be, you should try mediation now, and I'm stating the case. So we can expect to see a growth in the number of complaints handling schemes. We can expect to see some happy housing law practitioners and social housing organizations. And we can expect to see, it seems to me, a lot more mediation activity and hopefully a decline in the number of cases which are clogging up the courts and waiting to go to trial. Thank you.
Rob, thank you very much indeed. Well, that's been a fantastic tour de force, I think, of a presentation, which has really gone at a fantastic canter through the landscape of mediation and the current situation. What I'm going to do now, Rob, is I'm going to invite Dr. Isabel Phillips, who, for those of you who weren't on the call right at the beginning, is the Director of Policy and ADR Development at the Chartered Institute of Arbitrators. So, Isabel, if I can, I know you well enough to say, can I limit you to 5 minutes? Because I know that you know this topic inside out and backwards. And then, Rob, whilst that's on, you can have a quick look down the Q&A, and I've got 8 questions, or there's about 6 questions in there. And then I'll ask both Isabel and Rob to field those questions and indeed any others that come up. So, Isabel, if you'd like to just say a few words, I think, about what the Institute's approach is and where you think we're going.
Yeah, well, good evening, everybody. Lovely to be with you, even if we can't see you. It's, I think, a really pivotal moment in the sort of history of mediation practice in this country that we're seeing. I was involved in mediation in the UK back in 2004 when Halsey was decided. And for those on the call who were around then, the horror at the decision was really very palpable, I think, amongst the mediation community. So I think this has been really a really important moment, and we've been waiting 20 years for this case to happen. And I think it's interesting that, and there's a number of sort of signs of just how important this case was viewed as being not just by the mediation community, but also by the legal community and by the courts. If you look at the fact that we had the Lady Chief Justice, the Master of the Rolls, and Lord Justice Burse as the judges in the case of Churchill, it really does indicate just how important they saw this as being. And I think there is a huge focus within the courts and within government on what to do about the difficulties of access to justice within the country. And I think the acceptance that ADR has a fundamental part to play is very clear. I think a couple of things that are interesting about the Churchill case that struck me are, one is that one of the things that Foss very deliberately didn't do was to get into the question of what ADR is. Completely bypasses that question. And of course, I mean, I've worked all over the world, and what in one context is included in ADR is utterly excluded in others. So in some contexts in the UK, mediation and ADR are seen as pretty much the same thing, whereas for others, and that arbitration, for instance, is absolutely not ADR. In other parts of the world, arbitration is fundamentally seen as part of ADR as well as mediation, and then adjudication is also seen as part of the family. But the interesting thing in Churchill is it takes that to a whole other level, because the case of Churchill was not about mediation, actually, in terms of what was involved. It was about an internal complaints procedure, or actually a corporate complaints procedure, to be precise, which is a different beast again, because there's no neutral involved. So one of the things that it really throws up is the question of how different parts of a system of complementarity work in relation to different steps, so contingency of what you do at what point within the life of a case, and how those can be fitted together in a way that benefits people going through the system rather than redoing things or creating a barrier. And there's very different experiences in different jurisdictions. I spent quite a bit of time looking at different so-called mandatory mediation systems around the world, and there's a lot of learning that we in the across the jurisdictions of the UK could do to learn with, because we sometimes think, I think in the UK, that we're always ahead of the curve. We're really not. There's lots of people who've done this stuff first, so there's lots to learn from, which is great. So I think there's a few key thoughts. I think the second area of interest maybe for people is, firstly, that this, for me, is, having been around in this field for such a long time, it is quite groundbreaking that what we've done is to really try to work together as different bodies involved in mediation. So we proactively went out to work with CEDA and the CMC, so that we were actually talking to other bodies, and also to RICS, to actually talk to other organizations within the field. So we were actually trying to represent not individual organizations, but the voice of mediators across these different contexts, and to be much more inclusive by doing that. And we took that approach in actually intervening together. So CMC, CEDA, and FCIArb got together and were given permission to intervene in the case of Churchill, and that's, again, quite a groundbreaking thing to do. And it took a lot of obviously highly confidential work in the background to be able to do that, even to get to the point of being granted permission to intervene. So there's lots. I was personally heavily involved in that process. So there's lots I would like to say, and I probably can't say, and lots that and I could say, but I'll shut up at that point, because I've probably overshot my 5 minutes already.
Isabel, don't worry, because I'm sure you might have views on some of the questions that have come back in. But Rob, have you had a chance to look at any of the questions that are there? You're muted, by the way, Rob, at the moment, so unmute yourself. Right. We're not very good at lip reading. Dealing with one of the later questions,
yes.
Somebody asked the question about we've mentioned a couple of times that your slides will be sent to everybody, yes, but we have also been recording this evening's proceedings. So somebody asked if they missed the beginning. Now, I can't tell you yet where it will be posted. I believe it's likely to be on the Institute of Arbitrators YouTube channel. But once I find out where tonight's edited version, so that they don't have to put up with us chatting at the beginning and all the rest, an edited version will be prepared, it will be uploaded, and once I know where it's uploaded, I will then let everybody that's on tonight and who has registered, I'll give them access and tell them where it'll be. So,
sorry, Mark, jumping in. It'll be uploaded on our YouTube channel, but we can also post a link to that from our LinkedIn as well. So anyone who's following our LinkedIn page should see it on there, but also Mark will be able to sort of send that out with the email and the sites.
Thank you, James. That's great. So, Rob, rather than me intervene, if you want to pick up some of these questions, have you had a chance to look through any of the?
Some good stuff, some stuff that I've kind of said at one point in the process, but I'm conscious that when I'm interested in something, I start talking at 90 miles an hour because I'm just an excitable Geordie at heart. So I'll kind of just reiterate the points. First of all, Peter Corsten, you've asked a lot of questions, Peter. I'm going to do with a whole lot, if I may. First of all, you say, Rob, you mentioned CEDA a lot. Do you accept there are other mediation providers available? Absolutely. I am the chair of Northern Dispute Resolutions, a huge organization based in Newcastle. Very obscure. There are dozens, if not hundreds, of mediation providers and organizations, most of whom I don't personally know about. I mentioned CEDA because they are in Open and Invesco, so you kind of can't, I mean, fantastic product placement, but I can't discuss Open without discussing CEDA. B, CEDA are a player with CMC and the Institute of Arbitrators in the current MOJ negotiations. Again, I can't ignore them, so I mentioned them because I had to mention them. That's all. But other mediation providers, of course, there are loads, though I don't know that many. I know ADR Group Limited, I'm accredited with them. I'm accredited with Association of Northern Mediators and with Texor, I think. And certainly, I'm very happy to say I'm accredited with the Institute of Arbitrators, which I'm very pleased and happy about. So yes, there's loads, Peter. Secondly, do I agree it's wrong to refer to small claims mediation service as mediation? I'm not dancing on the head of that particular pin. They call it mediation. I wouldn't do a mediation that was 90 minutes on a telephone with no papers and preparation, etc. So I don't think it matters. It's an alternative mediation process. It's an alternative dispute resolution process. That's all. Then you say, how does the digital marketing bill regulation of mediators tie in the small claims? I don't know. So that's I know nothing about the digital marketing bill. Is adjudicator a protected name? I don't think so. I am an adjudicator myself. Construction adjudicator, but adjudicator to me is a noun describing a person who adjudicates, and that's most High Court judges. So they all are technically judging a case as adjudicating it.
Yeah, I think I'd agree with that, Rob. I'm an adjudicator, and I don't think it's certainly not a protected term such as a chartered surveyor or as indeed an architect. No. So I think anybody can call themselves an engineer, and yes, anybody can call themselves a surveyor, and I think the same thing applies for adjudicators.
Yes, exactly. Some nice message from Jane saying thanks for a highly useful talk. Thank you, Jane. That is a relief, actually. I'm pleased about that. Karen, you say costs must be the stake. Absolutely. We can't go around and beat people up till they agree to mediate. It's the cost threat is the first and best. There are two things that will make people mediate. One is just judicial pressure. Somebody older and wiser than you are saying, Rob, you've got to mediate. That's powerful, but even more powerful is, and if you don't, your client will sue you for losing the cost recovery. So yeah, I agree, costs must be the stick. Colin Robertson, have you ever had parties to mediation that were so obstructive that they, despite your impartiality, pressured you to promote their case and refused to back down from their initial position? Yes, I have. There's a case that went to trial in 2022, which is a well-known mediation case, which I can't quote because I was the mediator. And when I read, and they were just like that. And the obduracy was reciprocated on both sides. And heartbreakingly, they just spent a load of money, and they could have been so much better off on both sides if they'd kind of got to the outcome I sort of gently guided them towards. Yes, it's heartbreaking, but honestly, what I would say, Colin, and I'm sure you found this, is that very often people start and they look obdurate. I mean, so many times you read the papers on each side and think, that's a good case. That's a good case. How am I going to bridge this gap? Well, the fact is you are the bridge. You're the mediator. Your process is fantastically powerful and it works. So just as Confucius says, travel hopefully. You don't have to arrive.
If I can jump in, I think that there's a sort of rite of passage as a mediator to get a couple of actually Colin's question and then Andrew Milner's question as well. The one is the first time you meet people who are absolutely, completely, utterly intransigent. Doesn't matter what you do, it's just not going anywhere, because you have quite a lot of those cases that you start off thinking that and then suddenly something shifts. And so it's quite often early on in the case I'd also be like, well, I mean, I'm just going to have faith because I really can't see how this is going anywhere, and it does go somewhere. So don't give up hope too soon, but there are those cases that really are just not going to go anywhere. But I would say that the ones that really seem to make absolutely no progress at all are actually quite rare. What's more common are ones that don't settle, but there has been substantive movement and there has been a real point to the mediation because people are clearer possibly about why they disagree and what they disagree about and what they actually also do agree on. So the narrowing of the case thing, and this really is a really important part of why mediation is useful even when it doesn't settle. And some of those cases involve stuff where things come out of the woodwork that you could never imagine. So my favorite example, and I've carried on using this for years because it's just so perfect, was a case about a dog in a cultural context where half a dog was not an acceptable option as a settlement, but which was solved by gas and electricity certificates. And there had been legal proceedings going on for 2 years about this.
Yeah.
So, I mean, to Andrew's point, yes, and they absolutely, completely baffle you sometimes how this you've got there these settlements that have, because the case has been the actual dispute has been forced into a legal context, into a claim situation where it actually doesn't really have that much to do with it, but it's the only way that people have seen of trying to process this dispute, and that comes to
Isabel, I've got to ask, sorry to interrupt for a second. At the risk of extending this by a couple of minutes, you've got to explain how one half of a dog or an entire dog had anything to do with electricity or gas certificates. You better just explain that, because I'm going to be confused all night otherwise.
Well, to explain that, I'd have to go into oxygen cylinders, doggy dancing, and trailers. So I think I'm just going to leave
a subject for another night. So you're going to leave us hanging. Okay, that's fine. Rob, can I come back to you then on the just because we've got about another 3 or 4 questions that we need to address, and I'd like to make sure we wrap this up well ahead of 8 o'clock.
Right. Yes. Okay. Steve Hardy says, I'm a great believer in mediation, but isn't there an argument that some parties simply don't want to be there and if forced to participate may not properly engage? That's absolutely true. And one of the problems that you do find is that sometimes the lawyers own the case and are so passionate about it and they don't want their clients to settle. And I had a case about potato nematode worms. Again, a long story, and the things I've learned last November, very distressing because it wouldn't settle, and I sulk for days when I don't settle cases. And the solicitor for the claimant refused to have an opening session with the other side, refused to have, I was trying to do a log jam breaker in the afternoon. Let's just get the two parties together to talk to each other, the allegedly negligent agronomist consultant and the allegedly diseased potato farmer, and get them to talk to each other. And the solicitor said no, and he said, quote, I'm not exposing my client to anything that might challenge his belief in his case. So unprofessional. Wow. So, and we didn't settle, and it was very, so yes, the yes is the answer. So, you know, there will always be people out there, and they're not idiots. They, you know, we have to remember as mediators, we do not know the facts of the case. We will never know. You'll never know whether you did a good deal or whether you were a dupe of somebody's cunning plan. You just have to work within that process. You know, it's the human condition. So there'll always be things we can't settle, but I am confident that there are many, many cases that we will settle because it's such a powerful process. Annie, you're a volunteer mediator for a charity in Bucks. I sound like I'm on radio too, don't I? 42 years experience, and you like the Beatles. I deal with 3 or 4 cases a week. Wow. One of our mantras is, if you will, the law has no part in mediation. I totally disagree. Many, many cases where the lawyer is the voice of common sense, helps the party by being a sounding board. They can vent out, they can rant out, will be patient, is on their side, is reassuring and says, we need to close this down. We can't afford to take it to trial. You need to step back, breathe, think about it. So many excellent solicitors and barristers I've seen doing that. My hardest cases I found, maybe because I'm not very good, is litigants in person. I had a dispute about a bridal shop in Berwick. I can say that for safety because there are 4, or there were, and one lady bought this bridal shop from the other lady, a huge row about the stock. This is a £17,000 dispute, no lawyers on either side, and we found it after a long day because one party said to the other, I'm not settling by paying that woman any money. I could never hold my head up in Berwick again. So, you know, a solicitor would have given that context, taken her outside and talked her down off the roof. So I don't agree that if solicitors...
Can I give a counter view?
Yeah, go on.
I think that it's a bit about time, and it's a bit about where a dispute has got to. So I think this comes back to the Churchill thing about non-court dispute resolution. I think in disputes that have not yet been legalized because there are no solicitors involved and it's not, people are not yet thinking in legal terms, then absolutely there is a place. And of course, the vast majority, 98% of cases or something, never actually get as far as even getting lawyers, let alone getting as far as court, right? So people can and do need mediation when there aren't lawyers involved. That's a slightly different thing from when lawyers have started to get involved, and particularly if there's an imbalance of power. And I think, again, I've done quite a lot of litigant in person stuff, but I'm not a lawyer by background. And one of the things I've found is that some of that actually also makes a difference, that where you have a lawyer trying to work with litigants in person, it's sometimes more problematic for them because you see the world, once you're a lawyer, through a different lens, and you can't unsee that once you've trained. So I would say that there's truth in both positions. And do I sound like a mediator?
Yes, you do. Yes.
Rob, I think the last comment on the Q&A there is just thank you. Excellent presentation from Karen, who is a family solicitor and mediator. Good evening to you all. So I think that nicely winds it up. It just falls for me as the person who organised this to say a couple of thanks, which I should do in a second.
Mark, there is one final question.
Oh, is it? I missed one, would I? Sorry.
Jonathan Fingerhut, do you find one or both parties with mental health issues, especially autism, make it significantly more difficult to settle? I very tentatively, I'd like to offer this comment. 2 lawyers I know, both of whom I've mediated cases with, both rang me up, appointed me to do a mediation that was Tolata. It was a trust argument between a young man with severe autism problems and his mother, and he wanted possession of the family home to throw her out so he could live there. Long story. And they both said, we want this to be online. And I said, no, surely this is kind of a very personal thing, should be in person. No, we want to take all the emotion out of the process, because this young man will not be able to handle that stress. I don't know if that's right or not, but we did do the mediation remotely, and it did settle. So I've got no expertise in mental health matters at all, but I know that particular one did work because of the decision to distance it and cool it down by being online. Sorry to interrupt you.
Thank you. Well, thank you very much indeed. Yes, sorry, I'd missed that one. You're right. Okay. Well, look, just before I say thank you to our speakers this evening, I just want to take us back to the beginning of the thing, just to talk to the delegates and those who are registered about our branch of the arbitrators. We've got a lot of events coming up this year. Just to give you a flavour of some of the things we're going to be covering, we're going to be doing an evening on the cross-examination of expert witnesses, which is always a topic of interest right across the board. Many of our members are in the construction industry, so we've got some practical workshops both on construction payments, which everybody seems to get wrong, and also practical workshops on delay analysis. So these are things for later in the year. And I'll just mention again our next meeting, which is on the 7th of March, which will be in Milton Keynes, when Tony Bingham's talking on 25 years of adjudication and Viagra, which was more effective. I'm really looking forward to that. The advertising says that he's a very, very experienced adjudicator, but he's learning a little bit more about the blue pill. So on that note, I'm going to wrap this up this evening, and I'm just going to say a big thank you on behalf of the delegates, because what we've had is an absolute tour de force. What's come across to me is the passion of both of our speakers and the clarity of communication, because obviously it's patent the intelligence that you bring to the subject and also the experience. So I'd like to thank you both for the time you put into this. It's been an absolutely first-rate evening. Thank you, and I hope that everybody feels they got something from this evening. We look forward to seeing you next time. Thank you again, Isabel. Thank you very much indeed, Rob.
Thank you very
Thank
much.
you, Mark.
Take care,
And
everybody.
thanks for the audience.
Right. Okay, we'll now wind it up.
Right.
Good night.
Good night.
Good night.